You win some, you lose some, and we have lost some. So let's go ahead and talk about it. All right, you guys should be able to hear me now. You win some, you lose some. Rich, you're still on mute.
I'm on mute?
No, you're not on mute. I'm sorry. You were on mute. Okay, you win some, you lose some, and this is a case out of the United States Court of Appeals for the First Circuit. This was in front of a three-judge panel, and it dealt with the challenge of the Maine's waiting period, which is a 72-hour waiting period. There was a preliminary injunction, but that unfortunately has been vacated because the three-judge panel from the First Circuit ruled that waiting periods are constitutional. We are going to
Have
go
they
ahead.
heard of Bruen?
I guess not. So if you are a member of Crump Alerts at crumpalerts.com and sign up for $19.99 a month, you get alerts. It's already in your inbox, and this decision just came out less than 10 minutes ago.
Crump, I read the title and I mistakenly read it instead of first. I read it as fifth. I don't know why. I just glanced quick.
First Circuit, not the Fifth.
I'm like, the Fifth Circuit would never do that.
Yeah. So this was Maine. Let me just go ahead and break down this law. Maine, I don't have a lot of time. I got a meeting at 4. But Maine enacted a law in 2024 that required a 72-hour waiting period. They did that because the Lewiston bowling alley shooting. So yeah.
So here's my beef with all of these issues, and not to, this is not going to sound polite. We're talking about a small number of shootings that you're going to change and inconvenience a large number of people.
Astronomically small. So let's go ahead. I am going to show this, and we can read through a little bit of it. We're not probably to get to a lot of it, so we're just going to skim through it. It's only 24 pages. But this explains what it is, which I just explained, why they're suing, the injunction that they had. It explains the law. It's a lot of legalese. And then it goes into all this other crap. So this goes into the lawsuit, when the lawsuit was filed. Blah, blah,
did I
blah.
see Bruen in there? Did I see them mention Bruen?
Yeah, you did. So this is on appeal. And let's get down here.
I see Heller. And I like Dick. Heller.
So, actually, let's go up here. I'm deciding where to start reading from. Give me 1 second here. Let's all right, here. This is where.
We start with an overview of the challenge statute. The Act's central provision states waiting period. A seller may.
So you can skip all this. This is the same with
Okay.
Now just go down to here.
The Act does not apply to the sale of a firearm if the seller knows that the purchaser is a law enforcement officer, a corrections officer, a person employed by a contract security company or proprietary security organization, a licensed private security guard, a firearms dealer, nor does it apply to the buyer and seller are family members. The transaction between collectors for a firearm that is a curio and relic, the firearm.
Okay. So basically what it's just explaining the exemptions.
It doesn't somewhere, I know there's a document that says there's not more than one class of people and all laws apply equally. I'm not sure what
call the Constitution.
Oh.
But start from here.
The Act's legislative history demonstrates its intent to reduce suicides and homicides following impulse firearm purchase.
Which means nothing. Which should mean nothing. Keep on going.
Several legislators supporting the act pointed to an American Academy of Pediatrics report stating that waiting period laws governing firearm purchases reduce suicide and homicide rates. The report notes that
Which, okay, we can skip all that because that should
okay,
not matter. So that it just goes. So basically, why I wanted you to read a little bit of this. This is just all like stuff that shouldn't matter because it has nothing to do with the constitutionality of the law.
okay. On November 12th, 2024, plaintiffs filed this lawsuit and simultaneously moved for a preliminary injunction. The Attorney General opposed the motion and submitted declarations from 3 expert witnesses containing inter alia summaries of the history of American firearms regulation and descriptions of empirical evidence that waiting period laws reduce suicides and homicides. Plaintiffs did not contest
Which
this.
hold on, which shouldn't matter because that's interest balancing, right?
Yes, which was done away with Bruen.
All right, now let's go down to here.
The district court
Let's
applied
see how long you can go before I cut you off and say this shouldn't matter.
right. The district court applied the de facto two-step test that the Supreme Court prescribed in the New York State Pistol Rifle Association v. Bruen to evaluate the constitutionality of laws alleged to infringe the Second Amendment.
We all know this, right? We all know how
Yes.
this works. All right, go right, start from right here.
The Bruen court indicated, however, that the categorically unprotected does not mean immune entirely from the Second Amendment scrutiny. Laws that regulate conduct that is outside the Second Amendment's plain text, but nevertheless burdens the person's right to keep and bear arms, are only presumptively constitutional. Such laws still or may still violate the Second Amendment if the regulated party shows that the laws are being put toward abusive ends.
And this is exactly
So, shall
what
issue license
yeah.
regime is an example under which a general desire for self-defense is sufficient to obtain a concealed carry permit are presumptively constitutional. Their constitutionality would be doubtful if accompanied by, for example, lengthy wait times in processing license applications or exorbitant fees that deny ordinary citizens their right to public carry. Applying Bruen, the district court first concluded that at step 1, the Second Amendment's plain text covers the conduct regulated by the act which it characterized as the act of purchasing or acquiring a firearm. The conclusion led that the court to proceed to step 2 for Bruen states only if a firearm regulation is consistent with the nation's historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command.
we're gonna skip all this. This is just
The Second Amendment's unqualified.
did you go down here at step 2?
At step 2, the district court determined that the Attorney General had not shown that the act is relevantly similar to laws that our tradition is understood to permit. In United States versus Rahimi, quoting Bruen, the Attorney General had argued inter alia that the act resembled laws requiring background checks or licenses, which often engender delivery delays, and laws restricting firearm use by intoxicated individuals, which seek to temporarily disarm persons who may be experiencing short term lapses in judgment. The court rejected these comparators principally because, unlike the act, they involve individualized consideration by regulators of objective criteria. The court thus concluded that plaintiffs were likely to succeed on the merits on their facial Second Amendment challenge. The court also concluded that the plaintiffs were suffering irreparable injury and that the balance of equities and public interest favored issuing preliminary injunction.
Yeah, irreparable harm means basically harm that cannot be rectified by human monies. And a balance of interest always falls to the rights of the people.
On appeal, the Attorney General contends that the district court erred both in reaching Step 2 of Bruen test and in the way it applied Step two's historical analog analysis. These arguments raise questions of law that we review de novo. And they cite law, blah, okay, stating that under the abuse of discretion standard applicable to the review of a preliminary injunction, questions of law are reviewed de novo. As we explained below, we agree with the Attorney General that the Act's constitutionality can be addressed at Step 1 of Bruen and that the Act is likely constitutional.
So basically, they're saying, oh, we don't have the conduct. It's not protected.
Wow. Buying a gun is not protected.
Yeah.
Wow.
All right. You can just go here.
As a reminder, the Step 1 of Bruen asks us to decide whether the Act curtails conduct covered by the Second Amendment plain text, which states that the right of the people to keep and bear arms shall not be infringed. U.S. Constitutional Amendment 2, therefore, we must decide whether by imposing a 72-hour waiting period for the delivery of a purchased firearm, the Act infringes the textual right of the people's right to keep and bear arms, U.S. Constitutional Amendment 2.
Hey, Rich. A right delayed is
a right denied. And as I famously always do, I compare this to the right to sit at the front of the bus that you do not have in the Constitution. But if you said people you'd have to wait 72 hours to sit at the front of the bus, there would be all sorts of lawsuits. But apparently, the Second Amendment can wait 72 hours.
All right, keep on going.
To support the threshold contention that the district court should have stopped at Step 1 of Bruen, the Attorney General argues that the Act does not curtail conduct covered by the Second Amendment's plain text and therefore presumptively does not violate the amendment. He contends that the amendment literally says nothing about any right to purchase or otherwise acquire arms, much less to do so immediately. Thus, he says the Act does not infringe on the right to keep and bear arms because purchasing and acquire arms are materially distinct from necessarily antecedent to possessing and carrying a firearm.
All right, stop right there, because courts have said over and over again, if you look to McDonald, for example, that there is no right to bear arms if there is no right to acquire arms.
I know there are multiple lawsuits that basically say, yeah, this ain't happening. You got to be able to buy them.
Yep.
This conclusion.
Well, you can skip all this because this is all bullshit. So basically, well, fuck it. Let's just skip everything.
You are in a raw mood.
Because it's going against case law.
Yes. Yeah. And this is an activist judge judges trying to get the decision they want by piecing BS together.
Exactly. And if you can't acquire arms, you don't have a right to bear arms.
Wow. So, for the reasons stated, plaintiffs are unlikely to prevail on their claim in this communist court. Act is facially unconstitutional. Accordingly, we vacate the preliminary injunction, enjoining the Act's enforcement and remand for further proceedings so ordered. Holy effing cow.
So they're going to send it back. I would immediately file for an en banc on this.
Oh, damn right. Did Ketanji Brown Jackson, give any kind of amicus brief on this?
I don't know, but Kagan ripped into Ketanji Brown Jackson.
Really?
Yeah. If you read the last decision that came out about the Colorado conversion therapy.
Oh no!
She basically said Ketanji Brown Jackson doesn't understand the Constitution.
Good thing she doesn't have an important role interpreting the Constitution.
Yeah. But yeah, so basically this is probably going to go en banc. We're just waiting to hear what happens. I hate to cut this short, but I have a meeting in a couple minutes, and I really need to get to that meeting.
Alrighty, Crumpy. Important news.
Yeah, important news. And if you are subscribed to Crump alerts, www.crumperlerts.com. A small fee, 19.99, which some people say, hey, that's expensive. But hey, you're getting no news before anyone else. And if you would have got this, you would have got this with actual documentation. So let me just go ahead and show that really quick. I got to push this because this is how I am going to fund this channel from now on. So if you want to help fund this channel and the work I do, this is the way you're going to have to do it. So this is the breakdown that you would have got. Push notifications to the apps when they come out and directly to your inbox. And it talks about it. It breaks it all down. It gives you the holdings, outcomes, what the court said, how they came to the conclusion, and it includes the actual documentation as well. So, and I didn't show any of that. All right, let me do it again. So if you look, it breaks it down. It gives you the case numbers, dates, the key facts in the case, the legal issues, the Bruen framework, the one-step test and what the court said, the historical test, the outcome, the holdings and outcomes, and the significance, and it gives you the documentation. So if you
And
wanted to do
most
a
importantly, because it's bad, it's framed in red.
yeah, and it's framed in red, yeah. So if you wanted to do a YouTube video on it or something, there's everything that you need right there. With that, we're going to get out of there. Just check it out, crumpalerts.com. Help me do my work. Help me spend the money I need to spend to get places, to buy documentation, to just do stuff like that, and everything else. Thank you, LA Vino Latino.
Cool.
It really helps because it's expensive what I do because people just don't see like all the there's money being spent like out of my pocket more than anything else.
Oh, yeah.
Do this work. So I'm just trying to recover some money. I think I spent like 3,000 on stuff last month, getting stuff.
Wow.
So with that, we're out of here. Thank you so much, and we're gone. Bye.